This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawana Matanda.
I'm BJ Lomsal.
And I'm Jennifer Raphael.
Today we're chatting with Blake Frost, a partner at HopgoodGanim. He leads the firm's construction practice. Blake joins me to discuss why late payments remain a core driver of construction disputes, despite security of payment regimes being designed to prevent exactly that. I'm going to start by asking Blake about the paper he presented on late payments at the Society of Construction Law Australia's latest conference. Let's jump in. Hi, Blake. Thanks for joining us today.
Oh, thanks for having me on.
Your paper was really interesting and had a very direct title, Pay the Bills. The fastest way to deliver a project is to pay your bills when they are due. What prompted you to take such a straightforward approach to this topic?
It's an interesting one in that I sort of act in a pretty diverse practice here where I'm both contractor side and developer side, probably owner side more so than contractor side. And one thing I've noticed is that in many instances, the disputes arise because of late payment or non-payment. And you do ask the question sometimes, I wonder if some of these disputes could be avoided altogether. I did wonder whether or not, as a general statement, it's in both parties' interests to pay bills when they're due.
It was definitely attention-grabbing when I was looking through the options at SoCLA. And when you gave that talk, what aspects do you think generated the most interest from the audience or questions afterwards?
The way it was structured is to identify the problem and then have two solutions. And the first solution was a bit of a criticism or a critique on the Queensland security of payment regime. And I think having a lot of interstate colleagues in attendance at the national conference, that sort of brought out some surprise and shock in some of the characteristics of the Queensland regime and some real discussion around how Queensland's security of payment regime has got to be in the state that it's currently in. I think that was probably the part of the paper that grabbed the most interest.
Yeah, no, that was very interesting. And another thing you mentioned that was interesting to me was how Australia ranks so poorly in the payment timeframes compared to other countries. Was that something you were expecting to find, or was that a surprise?
It's actually something that I remembered seeing in the Murray Review many years ago. So again, when I sort of put this concept together and wanted to drill down into some of the details to support what I thought was a pretty sound hypothesis, I do recall seeing that, and it did shock me back then. But I guess having seen more and more of it over the last however many years in practice, I've just become accustomed to it now. It really is just part of the construction industry in Australia, and we seem to accept it for whatever reason.
Yeah. And turning now to Queensland, your state, the Building Industry and Fairness Act, which is the equivalent security of payment for that state. You explained that Queensland takes about 90 business days, so about 18 weeks, from payment claim to receiving an adjudication amount. That's incredible. Why is the system so slow, or why has it become so slow?
It's a pretty good question as to how it's become so slow. I think it was probably misused originally when timeframes were shorter, and parties, quite rightly, were using it to their advantage and ambushing opponents with very lengthy and complex claims. And I think one way to guard against that was to provide both a respondent with more time to prepare its response, and that in turn required that adjudicators get more time to prepare their decision. But I think it's probably gone a couple of steps too far. And on top of that as well, you're looking now at an extended time for claimants to provide an adjudication application. So even from that perspective, 30 business days, it can sometimes create an environment where parties are using it for the wrong reasons. They are using it more as a dispute resolution tool rather than that quick and dirty, imperfect system of just determining cash flow, I guess, for the project as it continues.
So it sounds like a mix of just legislative design issues and people misusing the system for their own gain.
Absolutely. And I think the legislative changes have probably tried to correct some of that bad behaviour, but it probably encourages different types of bad behaviour, unfortunately.
Yeah. And your paper discusses the rising trend of jurisdictional error. Can you summarise what that involves?
Yes. So The jurisdictional error part's an interesting one because it talks about the integrity of a decision made by an adjudicator. So adjudication is all about determining the amount of a progress payment that is due and payable to that contractor. It's a task performed by an adjudicator, an independent third party, and jurisdictional error is essentially where that independent third party, so not the claimant nor the respondent, where that independent third party has done something that is outside the scope of the Act and in effect impacts their decision. Now, why I think there is a rising trend of finding jurisdictional error is because more and more these days we're seeing respondents challenge adjudication decisions. So respondents in many instances are project owners or developers. They'll receive a progress claim. They won't want to pay that claim in full. So what do? They or the superintendent will certify a lesser amount. Now, when that's then referred out to adjudication, if the adjudication decision increases the amount that's payable under that claim, the respondent has one of two things they can do. They can either pay the amount and move on with the project, or what we're finding that they're doing more so these days is they're taking that adjudication decision to court and really trying to find any and every reason to set it aside so that they can resist paying those amounts.
As a transactional lawyer, I think that's a really great explanation of the adjudication process and some of the complexities that you're facing. And it sounds, again, like it's a combination of people exploiting the system, but the system itself having deeper issues.
Yeah, absolutely. And look, we as lawyers do play a little bit of a part in that. We all like to find jurisdictional error in decisions that we're on the wrong side of. And I think as more and more judgments are published, it becomes clearer and clearer where you can actually try and find jurisdictional error and attack some of these decisions. So certainly seeing a lot more of it now. I do throw some suggestions out there as to how that could be addressed, but by and large, where you've got a system that is designed by legislation, you're always going to have jurisdictional error because you're always going to have instances where individuals like adjudicators aren't strictly following the process in the relevant act.
The Taringa property case you refer to in your paper seems particularly concerning for contractors. Why is that case so significant?
It's significant from my perspective because it was one of those cases where a developer didn't certify a full amount in that progress payment. That was then referred to adjudication. It was a lengthy adjudication process where the claimant in that instance was awarded the amount of their payment claim. The adjudicator's decision was not unsurprisingly challenged, but it was actually held that there was not jurisdictional error there. So the decision was valid. And in that instance, you really have to think the money should have flowed through to the claimant. But what they did here is they put a stay on the paying of that amount because, one, the claimant there was insolvent, so there was a very high likelihood that that money, if paid to it, wouldn't be recoverable by the principal if the principal was then successful in litigation to recover that amount. But I think why that's a real issue is you get into this territory where you're potentially altering what a party's entitlement is in an event of insolvency. So I thought it was one of those instances where construction law and insolvency law are really colliding. And I think if you ask any insolvency practitioner what their views of that decision were, very, very surprised. But I think for us construction lawyers, we start to question a little bit whether or not the project trust account regime is being almost sort of set aside by some of the decisions like Taringa.
And do you think that decision has started affecting or influencing how contractors and principals approach these adjudications?
Possibly. I've had a couple of requests for advice since from different liquidators just about, well, what is their right to recover, I guess, amounts which are the subject of adjudication decisions. But I think we've probably got to step back and wait a couple more years to see what the actual flow and effects of that decision really are.
Yeah, that's fair enough. And in your paper, you suggest that Queensland's approach is out of step with sort of national best practices. What are some key things you think they could learn from other jurisdictions?
The one we touched on at the start is an important one, and that's just timeframes. I think the timeframes for making an adjudication application, for responding to an adjudication application, and for making an adjudication decision all need to be shortened. I think the ability for respondents and adjudicators to request extensions of time needs to be removed or really revisited. I think on top of that, whether or not there is anything you can do to try and limit the scope for a jurisdictional error, I think that's up for debate. But one thing we probably could do is remove the ability for adjudicators to request further information and submissions from the parties, because what we see there is that does really one of two things. It encourages adjudicators to go off on a frolic, and they often do, and then they justify that frolic with a request for submissions on the issue so that they can say the parties have been heard on that matter. And the other thing it also does is it encourages claimants to almost demand a right of response, which doesn't exist under the Act. So what we often see is an adjudication application is submitted by a claimant, respondent submits their response, and then a claimant will often demand to be given a right to give further submissions on certain items. And what they're really doing is they're outlining what their reply is. And adjudicators, more often than not, so that they don't feel like they're in a position where they haven't appropriately heard a party, they'll often invite those submissions, and then it's often coupled with an extension of time as well. So it also feeds into that overall duration between when the progress claim was originally submitted to when an adjudication decision is delivered and paid.
Yeah. And turning lastly to solutions and future outlooks, and I think your paper was a standout in this area in terms of talking about the ways forward. I think often as lawyers, we talk about problems and then we stop there. So you did a really great job. You've mentioned some of the practical suggestions now for improving the regime. If you had to pick one, and I know it's like choosing a favorite child, what do you think would have the most immediate positive impact if adopted today?
The most impact, I think, would be the first one, and that is moving away from what Mr. Murray described as the usual course, which is payment in arrears. I put in there's no reason why this can't change. I think that's in part true, but it's just such a radical shift. I don't see that anytime soon it would change. But I do feel like it's different in this industry where contractors will go out and perform this work without security from an owner and on the promise that they will get paid afterwards, which is very different to how many other transactions take place throughout Australia, where often it's cash first, product second. But for whatever reason in construction, we have it the other way around. And I do think that does create that power imbalance, that power shift. And I think that's what ultimately encourages a lot of the behaviours we see that give rise to the need for security of payment regimes.
No, I mean, that was definitely the most radical and most fascinating thing when I listened to your talk. How would you see that working in practice? And I guess what are the risks, if you're a principal or acting for a principal, what risks would they be worried about and how could they mitigate those risks? Security is obviously one way.
Yes, security is obviously one way, but the way I sort of see it is that the security risk there for an owner is quite low, because if you're paying a month in advance on day one, that's your maximum risk there for a builder who sort of leaves site having received that cash and not perform that next month's worth of work. Now, getting a little bit sidetracked here, to start with, it could be you could meet someone halfway. You could say, we'll agree that for this month it's X million dollars and we'll pay it on the 15th when theoretically you're approximately halfway through. That way, you're both sort of sharing equally in the risk. For the first 15 days of the month, the builder's at risk. For the last 15, the developer's at risk. And that risk obviously diminishes for a builder over the first 15 days and it increases for a principal in the last 15 days. Those types of arrangements, when you really think about it, the cost of a month's worth of work is very rarely going to be more than what a party would typically hold in security. So for a developer, you're very rarely going to be out of pocket. What you're really out of pocket for is those other costs that you like to hold security for. So additional costs of completion and other impacts that you'd suffer if that builder leaves site. But I guess the hypothesis really is that by adopting regimes like this, you're more likely to have that builder finish the project. You're less likely to have an event of insolvency where you are out in the market looking for a second builder and contemplating these additional costs of construction. If you can keep your builder on site, keep them happy throughout that project, chances are the overall project, as I suggest, is going to be completed quicker and cheaper.
Yeah, I mean, it's a real mindset shift, right? Because I think it makes so much sense on paper, but it's really getting people's minds to think laterally. And your paper mentioned that this might be a way that principals can get ahead or, be more attractive to contractors by offering this sort of payment arrangements. I mean, who wouldn't want their money in advance, right?
Oh, absolutely. And I think that's going to be something that here in Queensland with the topic of the Olympics, that's something that could really become attractive to a builder over the next 6 to 7 years as we have a lot of major projects come online. We've got a lot of energy projects as well there's certainly a lot of activity in the residential housing market as well. If you want to get top quality builders developing your project, you need to be attractive as a developer, and what better way to attract a developer than to pay them in advance?
Sounds good. And just turning back briefly to the Security of Payment Act, I mean, you suggested 5 really good practical suggestions in terms of how that act can be improved. Are there any of them that have gained traction or sort of conversation when you've been talking about this or thinking about this?
None of them have sort of gained traction as such, but certainly a lot of them have promoted discussion. So I had a lot of discussions after delivering that presentation with interstate colleagues that just almost didn't believe that some of these rules actually did exist here in Queensland. For all of those that have practiced in Queensland, we all have very, very similar war stories. The experiences are, I think, pretty consistent, and I don't think they're extreme changes to make. We're really in a situation here where the Queensland regime has just fallen out of touch with our interstate counterparts, and I think perhaps some minor change is required just to bring it back more in line with the New South Wales, the Victorian regime. The WA regime now mirrors very closely the East Coast model. So Mr. Murray, again, bring him up for probably the third time in this discussion. He talks about a national model. That would be fantastic, but I think as a second prize, we could at least try and have a model in Queensland that's a little bit closer to the East Coast model.
Yep, definitely. And I think Mr. Murray owes you some credits or something for your mention of his paper.
I'm just disappointed it didn't go anywhere.
No, I think you're reviving it, so there's hope, right? So obviously Brisbane 2032 is very topical, and it's fast approaching, you could say. How optimistic are you that we'll see meaningful changes to the SoCLA regimes in time?
Oof. It's a good question. We've had a change of government here, and I don't necessarily suggest it's going to be government driven, but I do think this new government we have probably has other focuses right now. So I'm not holding my breath that we're going to see any changes in the next 12 months. But certainly throughout this term, I think there will be a focus at some stage on the building industry. There is a focus on the building industry, but other aspects of it. But hopefully in the next 2 to 3 years, we do have a sensible discussion here in Queensland around what this regime should look like, whether or not those changes that we've seen implemented over the 8 years since the VIF Act was first introduced, whether or not they are having the effect that they were intended to have. And that's not just security of payment, that's the introduction of the project trust account system and some changes there around subcontractors' charges. I think like any piece of legislation that's introduced, there is that review after a few years, and hopefully that's not too far away, because I do think we need to have some change here in the next 2 to 3 years. Otherwise, it's probably going to be a fantastic time to be a construction litigator and an adjudicator, and a terrible time to be a builder.
Yeah, and I think it's going to be very interesting times ahead. Blake, thank you so much for a really insightful and interesting conversation. And I feel like, there's a lot more to go. I'm sure we'll hear more about this act and this regime as things progress.
Wonderful. Thanks very much for having me on.
That was Blake Frost, a partner at HopgoodGanim, where he leads the firm's construction practice.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au. This show was produced with strategy and production support from Sound Cartel.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Moana Matanda.
I'm Bijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.